It's because a lot of schools do not offer flexible paths to get a degree. Tom Busby, CNBC.
Just in time for a style upgrade, it's Macy's men's designer suiting event with 70 to 85% off. Lauren Ralph Lauren and Calvin Klein wool suiting, originally $600, now just $149.99. Suits and suit separates, $79.99 to $169.99. Sport coats and blazers, $39.99 to $79.99. Dress pants, shirts, and ties are just $14.99 to $24.99. Right now at Macy's. Savings off regular and original prices. Exclusions apply.
This is John Greenhut, and if your teeth are stained from coffee, tea, or smoking, Power Swabs is the answer. In 5 minutes, you'll see 2 shades whiter teeth, and in 7 days, 6 shades. Even better, there's no messy strips or trays that you'll have to leave in your mouth for an hour. Just swab your teeth for 5 minutes, and you're done. To try Power Swabs, call 1-800-679-0969. Your bright white smile will have your friends talking about how great you look. Try it risk-free. 1-800-679-0969. That's 1-800-679-0969.
NBC News Radio, I'm Tom Roberts. Governor Andrew Cuomo says the crash that killed 20 people in upstate New York involved a driver who wasn't properly licensed. Cuomo added today that the limo failed inspection last month and should not have been on the road. Michael is now a Category 1 hurricane with maximum sustained winds of 75 miles per hour as it barrels toward Florida. President Trump says Michael could be a very strong hurricane as it churns toward the Florida Panhandle or Big Bend area.
And it looks like a big one. Can you believe it? It looks like another big one, but we've handled them well. We handled them very well.
President Trump says he has no intention of firing Deputy Attorney General Rod Rosenstein. The president said on the White House lawn this morning that he and Rosenstein have a very good relationship. Brett Kavanaugh is now a member of the U.S. Supreme Court, and his first cases begin this week. Kavanaugh was technically sworn in Saturday after being confirmed by the Senate, but President Trump says there will be another swearing-in ceremony this evening. Tom Roberts, NBC News Radio.
This segment is sponsored by Tammy Sutherland of Coldwell Banker Kivett Teeters Realty, where she makes it her business to put happy people in happy homes. It's Tammy Sutherland's passion to list your house and put you in just the right house that you could call home.
She made so much extra effort to sell our house and make sure that we understood every step of the way. Tammy always had our best interests at heart.
I didn't think we'd ever find a house we loved, but with Tammy's help, we did. Now I get to mow the lawn every weekend. But then again, that's why we had kids. Hey, Tyler.
Tammy did way more than we ever expected in a real estate agent. Without Tammy, we would still be renting.
So if you want your perfect house, contact Tammy Sutherland at Coldwell Banker Kivett Teeters Realty in Yucaipa, across from Yucaipa High School. Whether you're looking to buy or sell, it's homesbytammy.net or on Facebook at facebook.com/Realtor Tammy Sutherland at 909-556-2094 for Realtor Tammy Sutherland, and we thank her for her support.
Are you having trouble sleeping? Are you always tired and worn out? Is it affecting your work and personal life? Well, South Pacific Sleep Lab can help you out. South Pacific Sleep Lab provides a personal study of your sleep patterns. With their trained specialists, they will diagnose your sleep habits and will give you a prognosis for getting a great relaxing night of sleep. South Pacific Sleep Lab has locations throughout Southern California, including Fontana, and will provide transportation to any of their locations at no cost to you. To find out more, give them a call at 844-SAD-5050. That's 844-SAD-5050. South Pacific Sleep Lab. Start resting easy and sleeping sound today.
News, weather, and talk on KCAA 102.3 FM, broadcasting to the Moreno Valley, Corona, and Riverside.
Erin here from On the Brink Morning Show, where we talk about all that is engaging in the Inland Empire. News, politics, business, family, things to do, and so much more. Join us weekdays from 6 to 7 a.m. on KCAA 102.3 FM, 106.5 FM, and 1050 a.m. or on KCAAradio.com.
KCAA.
Now, it's For the People with Judge Herb Dodell.
Well, good afternoon, ladies and gentlemen.
Gary tells me these great stories. He's like a warm-up guy, you know. It's like before once went to one of these TV shows, one of these nighttime TV shows, and before they actually start the show, they got a comic that comes out, does 10, 15 minutes, but he's the warm-up guy, right?
Oh yeah.
So you're the warm-up guy.
I am. I'm making you
But
laugh before the show.
you should be a very happy man because you won your bet. As we say in the courtroom, may the record reflect. I am handing this man right now a bottle.
Oh my Lord!
Of what's it called? It's called Tequila Esperanto.
Wow.
Selección. Now, Shelley tells me you can't even get this anywhere. It's better than Patron.
Really?
Yeah, we bought it actually when we were in Mexico.
Wow. Well,
we were in Cabo, no, we were coming back from Puerto Vallarta, and she loves to stop in these, the duty-free places, and this was the top of the line.
Well, thank you.
She was saving it. I said, no, let's give this one to Gary. And he won. Hard fought, but he won. But I also want to say, you may have been right, but you remember what I said. If the investigation came up with nothing, he should be confirmed.
Yes, you did say that.
That's what the Constitution says. The president has a right to nominate anybody that he or she wants to. Whether you agree or you don't agree as to the depth of the investigation, that's the deal that the Democrats and the Republicans made.
Well, thank you,
I'm sure
Judge.
they did whatever they were going to do. And
can I see my tequila?
Yes, it's a box. You have to open up the box.
I know. Let me look at it. I want to see.
It's a nice looking bottle. It's a nice looking bottle. It's a great looking bottle.
Thank you. Oh wow! Oh, look at that.
That's a great bottle.
Beautiful. I can maybe make a bong out of it afterwards or something.
Well, you're creative. You're definitely creative.
Thank you.
But I'm kind of glad.
I'm
kind of glad that this Kavanaugh thing is basically over, even though you don't think so.
Well, we'll see.
It is what it is. But what really the end result is that you no longer have a court of 4-4 and 1 swing vote, where you never know the 5-4 was going to be in one direction or the other. That is no longer an option. It is now clearly 5-4 for the conservatives. And so for the next umpteen years or however long Ruth Ginsburg lives, it's going to be a conservative court. A conservative court will certainly offend a lot of people. But if you look at it actually, and I don't want to turn this into a political show because it's not. If you look at it, there were a lot of things that were in this case, the side issues, whatever. The lateness of the investigation, sitting around for a couple of months. Maybe this was a political hack. Political hacky job.
Well,
maybe so.
Dianne Feinstein had the material or whatever since July, and she sat on it. And they could have done a private investigation on it, with thorough investigation with the FBI and all the Judiciary Committee could have heard it, privately, and not had it be a spectacle like it turned out to be.
Well, look, this was a last shot to the Democrats. They knew that they had to do something. Otherwise, it was going to be a done deal. And it's not beyond the pale of reality that this wasn't all set up. And what got me ultimately in having discussions over the weekend, even though the wives always tell their husbands, don't talk politics when we get together. Well, we had a group of our friends together, and naturally it becomes a subject matter of discussion. And someone said, and if it's true, and I believe it is true, then you have to reevaluate everything. They were saying that when Dr. Ford went to see the psychiatrist and mentioned this event having taken place in her life, she did not identify Kavanaugh.
Oh, really?
Now what you got is a question of whether there was any corroboration or not. There did not appear to be any corroboration. Without any corroboration at all, whatever standard you apply, whether it's beyond a reasonable doubt, prima facie, preponderance, whatever it is, there was really nothing there. And even though the presumption of innocence doesn't apply to these kinds of proceedings, it really is a very important part of our democracy. And it was part of the preparation for the Constitution as well, the presumption of innocence. And I think at the end of the day, there just wasn't enough for any reasonable-minded person to believe that it was sufficient to keep this guy off the court. Whether you like him or you don't like him, whether he lied or he didn't lie, was insufficient to justify a no vote. So it's done. And the purpose of this show is not to do politics. We kind of got off a little bit because we had Roger Stone here a couple of weeks ago, and that's pure politics.
Well, you're a judge too, and the Supreme Court's the highest court in the land. So, I mean, you had to discuss some of it. If you just blew it off, it wouldn't,
Well, yeah, I try to integrate whatever is happening in the legal system with equitable things as well as equity to determine where we're really going here. Today, we're going to change direction.
Okay. Can I have a shot of tequila while we do that? I'm joking.
I'm sure you probably would. You got a little glass?
No, I have to mediate something today between my cousins, so I have to.
Oh, that's what you called me about this weekend.
Oh
right?
my God,
I got that.
It's crazy.
Anyway, the bottom line is, and I mention it often, is the show's got really four purposes. One is to inform the public as to the legal system and how it really works from the inside, taking into consideration the fact that I practiced full time as a trial lawyer for over 50 years. And next month will be my 10th year on the bench.
Congratulations.
So, yeah, well, I'm doing less and less because I want to do more and more with my book and things like that. But the reality is we want to give guidelines to people on subjects that they don't normally get. And many, many people are confronted with serious debt issues in their lives, all the way up to the president. And so in my book, I did not talk too much about bankruptcy because I'm not a bankruptcy lawyer. Although, believe it or not, when I was in law school, I did my honors paper on a bankruptcy concept, which I'm going to talk about today, but had nothing to do, for the most part, for many, many years. Every now and again, you get a little bankruptcy-related issue, but nothing of such degree where I could consider myself an expert. And so I went out and I got a real expert today who's going to talk about bankruptcy from A to B to C to D to the whole thing. Cool. They usually deal with numbers, there's chapter 7, there's chapter 11.
Chapter 8.
I always wonder what happened to 8, 9, and 10, but I never did figure that one out. Then it goes from 11 to 13.
Why?
What happened to 12?
Yeah. Lucky number 13.
It's like in cases in litigations. There's a first party case, which means you're suing somebody with whom you have a relationship, and there's a third party case. What happened to the second party? I have no idea. There's a second party somewhere.
Of course there is.
When you sue a third party, it's somebody who did you some damage.
Right.
And usually they're represented by insurance companies, so they call those third party cases.
That is weird.
So I've engaged a guy, I invited a guy to appear today who's a real expert. He's been doing this for 30 years. It's all he does is bankruptcies. And from the simple bankruptcy, and you see the ads on the bus stops, it says, $279 to do a bankruptcy for you. It's pretty cheap.
Yeah.
And then you have those that are running into the millions.
I'd like to know how, it affects your credit,
Oh, it definitely affects your credit.
In what way? I mean, but I mean, in what capacity? That's like what I'd like to ask him.
Well, I'll tell you what.
About.
You can ask him.
Oh, thank you.
His name is Raymond Aver, A-V-E-R. He's on the west side of Los Angeles.
Okay.
I met Ray probably 8-9 years ago in connection with a case where we had a bankruptcy issue on the side. We weren't on the same side. There were multiple parties. He was representing one of them. And I got to like him. I said, this is a good guy. Not only is he a good guy, but he really knows his stuff. And that's a special world, that bankruptcy. They got their own judges. They got their own buildings. They got their own rules. That's a world of their own.
There's actually a bankruptcy court right where I live off of
Canoga.
Yeah, out in Burbank and DeSoto.
Yes,
right
that's
there.
right.
Yeah.
I've been in there.
It's right by my gym. Yeah.
Yeah, I had a guy, one of my former clients went bust on me and stuck me with a big bill. And that's where his bankruptcy was.
How nice is that?
He was a lovely man.
I'm sure he was.
But you know what? He started another business. And I used to drive by there and try to keep myself from feeling any negative feelings about the guy because I don't want to go there.
Throw rocks at the window?
No, but he's busted out again.
Oh, wow.
So yeah, he may have paid the price for doing it to me and others.
Karma.
So we're going to call Ray at 4:15, which is right now.
Okay.
And during the break, you can ask any questions that you want.
Yeah, I'd like to see how it affects the credit.
I got a few, too, and we'll see if we can help the public understand the system.
All right, it's for the people of Judge Herb Dodell. If you have a question to ask him, or you want to, feel free to ask him a question. Email him, askjudgeherb@gmail.com. We'll be back right after this with the judge.
1050 AM, KCAA.
Herb Dodell is a lawyer and a judge for the people. Having served as a Superior Court judge, presiding over more than 9,000 cases, he has witnessed firsthand how complicated and corrupt the legal system can be. His goal is to show how things really work in the legal system so that people can navigate the legal system in the best way for them. Many people often feel marginalized by the legal system and are uninformed about how to proceed when unfortunate circumstances arise in their life. Judge Herb will pull back the curtain, lift the veil, so people can truly understand their rights, have access to top legal personnel that they can trust, and have knowledge about how things work so they can make better choices. Judge Herb isn't just knowledgeable. His integrity and spiritual values are truly what make him different. He cares about democratizing access and information for all and desires to turn on the light so the people, you, can benefit. For more information, email the judge at askjudgeherb@gmail.com. That's askjudgeherb@gmail.com.
Well, as we speak, somebody's probably going bankrupt because Ray has got us on hold.
I think he might be there, Judge.
Okay, here he comes. Maybe.
Are you there, Ray? I guess Ray is not there.
Oh.
I called.
We're not hearing all that
We're not hearing anything.
elevator music or anything?
No, we're not even hearing the elevator music now. I don't know what's going on.
Well, what I'm going to do, I'm going to give you folks in the audience a little preview so that when he does get on the line, you'll know what kind of questions I'm going to be asking him, and I think Gary's got a couple of questions to ask him as well.
Yes, I do.
No, but
the call just dropped out, Judge. So I'm gonna have to call. We'll just do it right on the air. How's that? We'll just
okay, sure.
It's live radio.
This is live, absolutely.
Why don't you talk to her?
It's a reality
show.
show.
Maybe she thought I was just
It's a reality show, right? So it's a reality.
Yes, it's a live show.
Reality. Sometimes you call people and not there. But I spoke to him this morning.
Did you?
Yeah, I did.
Okay. Well, she should be picking up. There you go, Judge.
Where's Ray?
Where's Ray, dear?
Can he call you back in about 5 minutes, please?
Well, we're on the air as a moment as we speak.
Yeah, we're live on the radio. You want? Let me give you the number. He can call back. All right, I guess he can call back in 5 minutes. Let me give you the number.
That's all we can do.
Does he? Can you write down the number for him to call back into?
Yes, please. Yes, please. Uh-huh.
Yes, this is not a podcast. This is live radio. Okay, it's 818. 850. 7784.
84. Okay, thank you so much.
Not 884. Can you repeat the number for me, dear, please?
818-850-7784.
Thank you very much. Okay, yeah, have him call us back. Okay, thank you.
Thank you so much.
All right.
Judge, nothing is for certain, right?
My Roger Stone call went better than that call, Judge.
Well, that one we held our breath because we didn't know whether Roger was going to call us back.
Well, that's right.
But this guy I spoke to this morning.
Well,
And I gave him a list of the things that I thought I was going to ask him about because those are the issues that I think the public is the most interested in.
Like what? Where's some of the?
I actually wrote it down.
Okay, cool.
Starting off with reasons for bankruptcy. Everybody is facing debt issues, doesn't know what to do about it. The credit card companies are calling you every day. The government is chasing you for the taxes. You bought some stuff and now they're coming after you for payment on that, and you can't do it.
Now, is that part of like a foreclosure too?
Could be. Could be. It makes a big difference.
That's what I'm wondering.
Foreclosures are oftentimes stayed. That's the legal term.
Mm-hmm.
This section I know, Section 362, because it is an automatic stay, and I used to deal with that a lot in unlawful detainer cases because people would come in and are about to be evicted, and they would file bankruptcy. And when somebody files bankruptcy and they're about to be evicted, you have to stop the eviction.
Really?
You have no jurisdiction. You cede jurisdiction to the bankruptcy court.
Okay, so is that as a renter, owner, or both?
Any.
So if
362 stay, it's called.
So if I file bankruptcy, they want to evict me, out of my apartment building and I file bankruptcy, I get to stay there for how long? Usually,
Still until the stay has been determined.
And usually, how long is that?
Well, what the creditors are doing, lenders, creditors, is they go into the bankruptcy court and they ask for relief from the stay, and they almost always get it.
Okay.
And they present to the court a reason why the bankruptcy proceeding should not result in terminating or even delaying the outcome of a civil litigation. So this happens frequently. I understand the last time I asked the clerk was it takes like 3-4 weeks. So a tenant filing a bankruptcy can usually buy 3-4 weeks at the minimum until the next hearing is set. But there are a lot of reasons why people go bankrupt. You know, if you owe the government so much money and you can never pay it,
gotta go bankrupt.
You gotta go bankrupt.
Now,
not everything is dischargeable. See, one of the key words in bankruptcy, which you'll hear from Mr. Aver,
maybe,
well, is a term called dischargeable.
Okay.
Dischargeable. I'm going to ask him what that means. But for lay people, dischargeable means you end up not having the debt anymore.
Mm-hmm.
It's discharged.
Okay.
Creditors hasta la vista. And they have meetings of creditors and all kinds of things. And there's a big difference, which I want him to explain, between a Chapter 7, which is a liquidation. It's called a liquidation, meaning all your assets that are not excluded or not permitted to be not part of the estate. It's called the bankruptcy estate. Belong to a trustee. A trustee basically is engaged by the court, and the trustee owns everything.
Now let me ask a question, Judge. Can you file bankruptcy and still own a piece of property, or does that fall into the whole bankruptcy?
Well, I don't really know, but I think you have to list it.
You'd have to list the property.
You have to list it, but I think there's something called a homestead exception. There are other exemptions. Rarely do they force, I shouldn't say rarely. It's probably less likely that they're going to force you to sell your house or foreclose on your house because, of course, it's an asset.
Right.
And then there are usually secured creditors. Now, there's a difference between the creditors. I was going to ask Ray about that, too. There's secured creditors and there are unsecured creditors. And what's the difference? Is there a special protection? Obviously, if there's a special creditor, they get priorities.
Mm-hmm.
And in many business transactions, they list things as stock owners of A stock, B stock, C stock, things like that. And so in a Chapter 7, the trustee takes over everything and they sell it. You can buy it from the trustee. Actually, the trustee will sell it back to you sometimes. Like if you own your own business and you're a professional dentist or whatever, you can put a value on it. The trustee may not agree with your value, and you buy it. You buy it out of the bankruptcy.
Wow.
So you're not, you don't lose it, but you have to find some way to pay for it. And that's secured creditors and unsecured creditors. And then there's something called the Chapter 11.
That's the big one. Everybody says, I'm filing Chapter 11. That's what you know.
Well, many times you can file a Chapter 11. You start as an 11, and it gets converted into a 7. Now, what does that mean in English? I'd rather have the expert tell you than I tell you. No. A Chapter 11 really says to the debtor, okay, figure out a plan.
Mm-hmm.
You know, how to pay the creditors. Figure out a plan. You're going to put money in. You're going to take your receivables. You're going to contribute some amount of money. And you put together a plan. And you get to keep operating control of your business while this bankruptcy is proceeding, as long as you follow the rules. And there are these special rules that apply in bankruptcy court, which say you have to report a certain amount of time. There's certain business that you could do, certain business you cannot do, and you have to report to the bankruptcy court and kind of follow up with it. If the plan is approved, it has the same basic effect, except that it allows you to continue your business, even though you're under what they call the protection of the bankruptcy court. And so if you don't follow all the rules or you don't do what you say you're going to do, they convert it from an 11 into a 7. And when they convert it into a 7, they sell all the assets, all those non-exempt assets that are available for all the benefit of the creditors. And the creditors have a creditors committee meeting. Most of the time, nobody shows up at these creditors' meetings.
Why?
Because there's very little these creditors can do on credit card debts and things like that. They don't even bother.
They have to eat it.
And even they do, but they write it off.
Of course.
And the government also rarely comes to these things either, unless there's a pending inquiry or investigation going on where it's a real issue as to whether or not it's legitimate. And so the 11s can stay in 11. You keep your business operating. You make a deal. You take a big debt and you make it a little debt. You know that old joke, you know how to make a small fortune?
No.
Start with a big fortune. And
that's good.
It's not mine. I quote that from somebody else.
That's pretty good.
But the fact of the matter, and then there's a 13 of which I know nothing. I think a 13 is a wage earner's plan. I have no idea what that is.
So 7's worse than 11.
Well, 7 eliminates all your assets.
Right. Takes everything.
All your subject assets.
Takes everything.
Some assets are not subject to being controlled by the bankruptcy court. I don't know what those are, but it's in the code. This is all statutory. There's lots of forms.
Yeah.
And the lawyers do real well in the bankruptcy court.
Why? How can they do so well?
Because they're at the top of the pyramid. They get paid first.
Oh, they get paid first out of the bankruptcy. That's something first out of the bankruptcy.
First out of everything.
Wow.
And sometimes the lawyer's fees will eat up all the assets. They're administrative expenses, they call them, as I recall the term. Administrative expenses means they get paid first. And the lawyers put their bills in, and they sure know how to run them up. I can tell you that.
I bet.
I've seen them. I've seen where some of those.
Can the judge tell them to cool it and take some of the funds away, or is it just sort of like?
Well, it's like anything else. You know, I told people before.
I think here he's calling in right now. Hold on.
Okay.
All right, here we go. Do we have Ray here?
Hello.
You are there.
I am here.
Well, we've been talking about bankruptcy. In my limited knowledge to fill the time until you got here. I'm sure
you probably already have it covered. Then you don't need me.
I have it covered, but the question is whether it's right. You know, it's not covering it. It's making sure that the information I'm giving these people is accurate. Now that we have a real pro here on the other end of the phone.
You want to reintroduce him, Joe?
Yes, absolutely.
Thank you.
Who is he?
I don't know. It's your guest.
Okay.
What's his name? Ray.
I thought it was your guest.
No,
Roger
Stone was my guest.
Oh, okay.
This is your guest.
Ray Aver is my guest. AVER. And Ray's a bankruptcy expert, been that for 30 years. And so I listed a couple of things I wanted to address to you, Ray. And I'm going to give them to you, and then you can expand on them and explain all of these things. One is the reasons for bankruptcy. Why do people go bankrupt? And another is a definition of dischargeable versus non-dischargeable. Explaining that. The difference between a 7, 11, and a 13 with different results and what happens when those people file under each of those chapters. Qualifications, who are the judges, who are the lawyers, general procedures, limitations and requirements.
A lot of questions here, Judge.
And forms. And I also added something. I was thinking about it because when I had been involved with you before, Ray, about 10 years ago, 8, 9, 10 years ago, it involved something called a preference. And I think that's a very important subject to discuss because many people think that they're going to get sued, they're going to lose, somebody's going to get something from them, so they just transfer their assets out to somebody else, like a relative or a friend or a business associate in one way.
Like Trump did to his kids when he took president?
Well, it's a way of keeping the assets away from the creditors.
Okay.
So I'd like you to talk about that too.
I think you're thinking of fraudulent transfers. Or
yeah, same thing.
Sounds like Trump.
I think they're the same thing.
Sounds like
they?
Trump. No.
No comment. No, a preference is you're paying somebody to the benefit of them as opposed to someone else for whatever reason, and a fraudulent conveyance is to avoid the creditors. But you correct me, Ray, if you will, because you know a whole lot more about this than I do.
Let's take a break first, Judge, and then he can discuss it after the break.
Okay, that makes sense.
All right, I want to find out how bad it hurts your credit if you file bankruptcy. A lot of people want to know how bad it is for your credit. Is that okay?
Sure.
All right, cool. All right, it's For the People with Judge Herb Dodell, and we'll be back with more from the judge right after these important messages.
NBC Talk Radio, 1050 AM, KCAA.
In his book, From the Trench to the Bench, Judge Herb Dodell demystifies the legal system, including both civil and criminal, the lawyers, the judges, and the process. As a judge, former deputy district attorney, and criminal defense attorney, he knows the legal system. He has the inside information that you need to pick a lawyer, and he's here to give it to you. No matter what you're facing that makes you think you may need a lawyer, Judge Herb will shed valuable light on your situation and reveal your best options and many secrets of how the judicial system actually works. To find out more about how the legal system really works, you can get your copy of Judge Herb Dodell's eye-opening book, From the Trench to the Bench, at Amazon.com.
Now.
Well, we're getting ready. Okay. Can you hear me?
For businesses and individuals. There are three types of bankruptcies that people can avail themselves of, although there is a Chapter 9 for municipalities, but we won't talk about that. We'll talk about Chapter 7, Chapter 11, and Chapter 13.
That's good. It's a good book.
Chapter 7 is known as the simple, straightforward bankruptcy. It's a straight liquidation. And typically people who file Chapter 7, and it's typically done by individuals, because individuals get a discharge, whereas companies, businesses, typically don't get a discharge unless they reorganize. But in Chapter 7, the bankruptcy is filed. A trustee is appointed to determine whether there are any non-exempt assets that can be liquidated and the monies used to pay creditors. Exemptions are a very, very important part of bankruptcy when you're an individual debtor, because property that is exempt from the majority of your creditors, with the exception of maybe the taxing authorities. And so you always want to think of your property as to whether or not it's exempt or non-exempt. For example, the most common exemption is the homestead exemption. And depending on how old you are and whether there are people living in the house with you, the homestead exemption can range from $75,000 to $175,000 under California law. In Florida, for example, it's unlimited. You may remember O.J. Simpson moving to Florida in order to protect his home from a homestead exemption. So at any rate, Chapter 7, it's very simple, straightforward bankruptcy, and the goal is to get a discharge. And what is a discharge? A discharge in bankruptcy is like an injunction or a bar. Those creditors that are listed in your bankruptcy case, who are listed, you get a discharge from them, and they can no longer pursue you after you get your discharge in bankruptcy. One of the benefits to a bankruptcy, Chapter 7, 11, and or 13, is that when you file bankruptcy, you get the benefit of the automatic stay. And so, for example, today a young man came into the office. He's in the middle of divorce proceedings, and he wants to change attorneys. And his new attorney needs to get up to speed on the case, and the case is getting ready for trial in the next couple of days. And so the strategy was to file a bankruptcy for him and to get the automatic stay. And this litigation that he's involved in is taking place in state court. And what happens is you file the bankruptcy. Bankruptcy is a federal system. And then you notify the state court of the bankruptcy filing, and the automatic stay goes into effect, and it stops most forms of creditor action. And in this particular case, it will stop this trial from happening. creditors can seek relief from the automatic stay, which they oftentimes do, and then it's up to the court to determine whether relief should be granted. But before anyone seeks relief from the automatic stay, it goes into effect. It's called an automatic stay. And if creditors take action to violate that automatic stay, knowing about the bankruptcy filing, they can be subject to contempt sanctions. Because when you file bankruptcy, a voluntary bankruptcy, there's an order for relief, and that order basically contains the automatic stay. So that's Chapter 7.
What about an involuntary filing?
Well, involuntaries are, they're kind of disfavored in the law. A voluntary filing is when you yourself file or the case is filed on your behalf. An involuntary bankruptcy is when your creditors get together and they file a petition against you. And basically what they're saying is that you are not paying your debts as they arise in the ordinary course of your business affairs. And if basically an involuntary petition is akin to a complaint, and the debtor has an opportunity to answer the complaint and either admit that it's not paying its debts and thereby become a debtor in bankruptcy, or the debtor can try and fight it. The problem is if you're a creditor and you are part of a team that files an involuntary bankruptcy, and if the debtor can prove that it is paying its debts as they arise in the ordinary course, then you, the petitioning creditors, can be subject to some fairly severe penalties. So it's a tool that a creditor can use, but they need to be careful about using it. So anyway, for an individual, they want to try and get a discharge. And an individual debtor in a voluntary case can get a discharge in 7, 11, or 13. However, if a creditor believes that the debtor has engaged in bad conduct, and that bad conduct could be bad conduct prior to the bankruptcy vis-a-vis that creditor, or it could be bad conduct in connection with the bankruptcy case itself, for example, not listing assets or transfers or things of that nature, because one of the prices you pay for bankruptcy is you've got to fully disclose your financial affairs. And you have to file some extensive papers with your assets and your liabilities and money you made in the last couple of years and transfers you made and so on and so forth. At any rate, creditors oftentimes, and I find that creditors do this through non-bankruptcy attorneys more often than they do through bankruptcy attorneys, because these cases are somewhat difficult to prove. They're called fraud cases. And so, for example, if a debtor incurred a debt as a result of fraud, if you, for example, made a promise to someone with no intent of ever fulfilling that promise, that could be fraud. Or if you gave a creditor a false financial statement in writing, or if you willfully and maliciously attempted to hurt someone. All of these things are pursuant to statute in the bankruptcy code, and you're going to want to talk to a bankruptcy lawyer about whether you have any exposure for any types of these pre-petition bad misconducts. But assuming that you don't, then you can get a discharge, and that, again, it applies in 7, 11, or 13. And as I said, a Chapter 7 is a straight liquidation. In a Chapter 13, it's called a wage earner bankruptcy, and typically people use Chapter 13 to save their homes when they go into foreclosure, when they've missed mortgage payments. And so what you do is, under the bankruptcy code, you can't modify a residential loan absent a consent of the lender. But what you can do is you can take the arrearages. So say you're behind 10 months in making your mortgage payments, and you're behind in paying your property taxes. Let's say you had a serious medical condition that you've recovered from, or you lost your job, or whatever the case may be, you've fallen behind on your mortgage payments, and the lender's threatening to foreclose, you can file a Chapter 13, and you can pay the amounts in default over a 3 to 5 year period through a Chapter 13 plan. Now, in Chapter 13, there is a trustee, just like there is in Chapter 7, but the Chapter 13 trustee really is only interested in a couple of things. One, are you being truthful in your bankruptcy papers? Have you listed all your assets? Have you listed all your liabilities? And two, have you provided accurate information to the court and to creditors to show how much your excess income is? Because your excess income each month is what's going to fund the plan. And excess income is simply your net income minus your expenses equals excess income. And you have to have sufficient amount of excess income in order to, for example, pay the arrearages on the mortgage and the property taxes that you fall behind. So it's always kind of an interesting exercise when meeting with debtors to figure out, can they qualify for a 13? By the way, there are debt limits in a 13. You can't have a little more than 1.1 million in secured debt and something like 390,000 in unsecured debt. But assuming you meet those limits and you have regular income, you can try to come up with a Chapter 13 plan. And we've been involved in a lot of Chapter 13 plans that have been fairly successful over time. One of the interesting things in Chapter 13 is if creditors don't file claims, they're time barred. And I remember, a number of years back, a colleague of mine decided that he was going to marry a divorcee who had been married to a doctor. And so he inherited this beautiful house that had at one time been inhabited by the doctor and his wife, and now is going to be inhabited by he and the doctor's ex-wife, and a huge mortgage. And he fell behind on the mortgage because I think he was changing jobs or something of that nature. At any rate, we filed the bankruptcy, and we were going to try and pay unsecured creditors something, but almost no unsecured creditors filed claims. And what happened was the real estate market was on an upturn, just like it is today. And during the bankruptcy case, which I think was a 5-year plan, but during the bankruptcy case, the house appreciated in value so much that he was able to refinance the house, pay off the arrearages on the home mortgage and property taxes, and everything worked out real well for him. So that's Chapter 13. Chapter 11 is probably the most complex of the 3 chapters. Again, Chapter 7, straight liquidation. Chapter 13 is a rehabilitation, so as long as you meet the criteria, your plan is confirmed. In a Chapter 11, creditors actually vote on your plan.
Gary has a question for you.
Well, yeah, he
Sure.
can go. I was just curious, when you file bankruptcy, and I'm sure this is a question the common man would like to know, is how bad does it screw your credit up? Is it for years and years, or is it a couple of years, or can you, if you do file bankruptcy, can you do anything about it during the bankruptcy?
Okay, so it's a common question that's oftentimes asked. Most times when people come to me, they do ask the question, but their credit is already in such bad shape that it's not a huge concern. And I'm not a credit repair specialist or a credit specialist, but I am told that lenders would much prefer to see a bankruptcy than a foreclosure on your record. If they see a foreclosure, then they think you have some real problems. But to answer your question directly, my understanding is a bankruptcy stays on your credit report for between 7 to 10 years.
Okay.
Now, I have colleagues who do credit repair, and they tell me that there are ways to get the bankruptcy off much sooner. What I tell people is that typically after you file bankruptcy and you've gotten your discharge, some creditors may be more interested in lending money to you than they were before the bankruptcy, because you've discharged whatever debt you had. You now have a clean slate. You're not making credit card payments. You're not, paying old debts, that type of thing. And so you should have more disposable income that you can use, and you can pay the creditors. But yeah, that it definitely is not a good thing to file bankruptcy for your credit. But again, most people who come to me, while their credit standing is important to them, there are many other issues that are more important.
How often can you go bankrupt?
You can go bankrupt. Well, that's. I mean, the real question is, how often can you get a discharge?
Okay.
You can get a discharge every 8 years.
So
you can file bankruptcy more often. So, for example, let's say the taxing authorities are, garnishing your wages and putting liens on your property and things like that. You can come up with a plan in a Chapter 13 to pay the taxing agency over 5 years in a 13. And if you don't pay them in full during that 5-year period, you could hypothetically, if you can demonstrate good faith and things of that nature, you can file another 13, or you can file a 7 and then a 13. People do that when they don't qualify. For example, they don't meet the debt limits in a 13. You file a 7. You discharge a bunch of your debt, so you come under the debt limits, and then you do your 13 to save your house or whatever it is that you're trying to accomplish. So there's all different kinds of strategies, but you can only get a discharge every 8 years.
Let's talk about our subject that I'm sure is near and dear to everybody's heart. That's taxes.
Oh.
Are taxes dischargeable? Different kinds of taxes, some dischargeable, some not? How does that generally work?
Sure. So excise tax can be discharged.
What's an excise
Trust fund
tax?
taxes cannot be discharged. So, for example, if you're the owner of a business and there are trust fund taxes like employee withholding taxes or something like that, those cannot be discharged. Those are trust fund taxes. Income taxes can be discharged if they're old and cold. And typically what that means is that the tax was due more than 3 years ago. It was assessed more than 240 days. So there are tests, but it is a common misnomer, or it's a common inaccuracy that you cannot discharge taxes in bankruptcy. So you can discharge what's called non-priority taxes, and with regard to priority taxes, those taxes that have been assessed, like I say, within 3 years of the bankruptcy, or the returns due within 3 years of the bankruptcy, you can come up with a plan to pay them, and that keeps the government happy, or at least it keeps the automatic stay in effect and protects you from wage garnishments and things of that nature, so you can kind of deal with the tax claims. Okay, going back, yes?
Go ahead. Let's talk about an 11 now, because that's the most prevalent.
Let's talk about an 11. So Chapter 11 is primarily used by businesses, but it can be used by individuals. And again, like I said, businesses are not eligible for discharges in a Chapter 7, and they don't qualify for a Chapter 13. But they can get a discharge in Chapter 11 if they truly reorganize through a plan of reorganization. Chapter 11 is the most expensive and time-consuming of the 3 chapters by a long shot. And basically what you do in a Chapter 11 case is you classify claims and you put them into classes, and the classes vote. And you've got to get, in order to carry a class of votes, you have to get more than 1/2 in number and more than 2/3 in amount. And Chapter 11 is, I mean, it's a very, very interesting process. People are afraid of Chapter 11 because of the expense, but sometimes you have no choice. Like, for example, the fellow who came in just the other day to try and stop this divorce from going forward thought he was going to be able to file a Chapter 13. Well, the problem is he has over $1 million in unsecured debt. So he doesn't qualify for a 13. But in a Chapter 11, we're going to be able to do a lot of neat things. So, for example, because he's been in this divorce, he's been unable to get authorization to sell the family house. And there's a substantial amount of equity in the house, and he wants to take that money and pay creditors. And so in a Chapter 11, you can sell property. You can sell property free and clear of liens in a Chapter 11 with the liens to attach to the proceeds. If there's a dispute as to a claim against property, sometimes you can sell the property over the disputed claim. In Chapter 11, there is no trustee. The debtor, the individual, or the board of directors of the company, they are the ones who make the decisions for the debtor, obviously subject to court approval when mandated, but you keep control. And you come up with a plan, and you pay your creditors. Just like in the other chapters, you get the benefit of an automatic stay. So, for example, we filed a case several months ago where this company was involved in multiple litigations and couldn't afford to keep paying the amount of attorney's fees and costs that were being incurred. And they were getting closer and closer to trial. And so we filed Chapter 11 for the company. We're in the process of negotiating with the creditors, basically by using the bankruptcy to let them know, look, here's a company, it's got a going concern value. This is what we can afford to pay you through a plan over the next 5 to 7 years. If you don't like it, then you can press the debtor real hard, but you're not going to do any better. And what is likely is the debtor will end up having to be liquidated. The company will end up having to be liquidated. And in a liquidation, you'll get nothing. So you might as well accept a nickel or a dime on the dollar over the next 5 to 7 years, because that's a heck of a lot more than you're going to get if the company gets liquidated.
Is that called a cram down or something like that?
Well, a cram down is a term of art. When you have a class that does not vote in favor of the plan, you can attempt to what's called cram the plan down on the creditor. It's different. Cram down is different whether you're attempting to cram down a secured creditor or an unsecured creditor.
What's the difference?
Boy, that's it's all statutory, and it's all set forth in the bankruptcy code. I'd have to pull the code out and take a look at it, but it's all in 11. That portion is in 1129 of the code, and that's the thing. The bankruptcy code is where the laws are. That's almost like the Internal Revenue Code for bankruptcy lawyers. If you have a question about something, you initially go to the code, and then you've got case law that interprets the bankruptcy statutes. You'd think that because it's one federal bankruptcy code that applies throughout the 50 states, that the bankruptcy laws would be the same. If you had a case in Alabama, than if you had a case in Maine, that you should be able to get the same result. But it's amazing. There is so much discretion that goes into a bankruptcy case and that is given to bankruptcy judges that I often tell people, you can take the exact same individual or entity. You could file a bankruptcy for them in downtown Los Angeles, and you'd get a judge on the 16th floor as opposed to a judge on the 13th floor, and you can get two completely, totally different results, because it's all a matter of interpretation. And again, there's a lot of discretion that goes with what the judges do or don't do. But that's kind of a 7-11, an outline of a 7-11 and a 13. Individuals and business individuals qualify for all three. Businesses again qualify for 7 or 11, depending upon what you want to do. If you're an individual and you want to file bankruptcy, you now have to take a credit counseling course. It's really not very complicated, but I've seen a lot of people who who try to cut corners. They don't hire an attorney and they file bankruptcy without taking the credit counseling, and the court will dismiss the case. You have to take the credit counseling before you file for the bankruptcy if you're an individual.
What does it mean when they say the bankruptcy court can dismiss the case? What does that mean?
Oh, it's just like it's dismissed. It's you've got a bankruptcy on your record, but you can't go forward with the case because you didn't comply with one of the prerequisites of the bankruptcy code for individuals, which says that you've got to take this credit counseling course. And so the case is dismissed. It no longer exists. And furthermore, it causes problems because for individuals, Congress in 2005 enacted a whole slew of laws, I think at the behest of the credit card industry, to make it more difficult for individuals. And so one of the things is if you filed a bankruptcy in the last year, it's dismissed, and then you file a second bankruptcy within that year, you actually have to go in within 30 days and get the automatic stay reimposed. If you don't get the automatic stay reimposed, you'll have no automatic stay after 30 days. And that can be a huge pitfall.
Is that called the 362 stay? Is that what that's called?
Yeah, 362 stay, exactly. If you file two bankruptcies...
I know something. Not much, but I know something.
If you file two bankruptcies in the last year when you file your third one, you have no automatic stay at all. And you've got to immediately run in on an ex parte basis and seek to have the automatic stay imposed.
Okay, we're getting down to the nitty-gritty here. One other thing I wanted to ask you is, you mentioned exempt property and non-exempt property. Can you give us a kind of a summary of what's exempt other than the house?
Sure. So exemptions, there are federal exemptions and there are state exemptions. And they're all statutory and they're all in the code.
Okay, that's easy.
One code or another.
Okay.
In California, California has opted out of the federal system. So the exemptions are contained under California law. And there are bankruptcy exemptions and there are regular exemptions. And the debtor can choose between the two of them, whatever. Basically one of the jobs of the bankruptcy attorney is to try and maximize what is exempt property. Because if the property is exempt, creditors don't get it, the trustee can't liquidate it, and it comes back to the debtor. It's as if the debtor never loses the property. So, for example, household goods and furnishings are exempt. Jewelry to a certain amount is exempt. Tools of the trade are exempt.
The Bible, I know, is exempt. No, your Bible's exempt.
Amen.
Hallelujah. Well, Ray, we're coming to the end of this very informative discussion. I've learned a lot, and I'm sure that our viewers have learned a lot as well. So you're Ray Aver, and your phone number is 310-571-3511. You have a website?
Yeah, we have a website.
But you have to hurry up and give it to me because we're going to get cut off in 43 seconds.
Okay, so you can email me, ray@averlaw.com. Or I think averlaw.com may be the website, but that'll work, and I'm happy to answer any questions.
Well, KCAA Loma Linda, 1050 AM, 106.5 FM, and now 102.3 FM.
Are you a small business owner or pursuing the dream of starting your own company? Do you know where to start or how to grow that existing business? The American Business Trust Company has the